Hi everyone, welcome back to the channel. I'm Brandon Silver, a construction, contentious and transactional lawyer in the UK, and as I mentioned in my previous vlog, today we're going to be talking about adjudication. Adjudication is a quick and powerful method for resolving disputes in construction projects. Adjudication has become a fundamental part of the UK construction industry, so today I'm going to break down what it is, how it works, and what makes it such an effective tool for resolving disputes. So, first of all, what is adjudication? Adjudication is a fast-track dispute resolution process specifically designed for construction projects. Under the Housing Grants Construction and Regeneration 1996, also known as the Construction Act, and which I discussed in depth last week, any party to a construction contract has the right to refer a dispute to adjudication at any time. One exception to this: no statutory right to bring adjudication where there is a construction contract with a residential occupier, i.e. a construction contract which principally relates to operations on a dwelling which one of the parties to the contract occupies or intends to occupy as his residence. This is a statutory right to refer to adjudication. You can also have a contractual right to bring adjudication. This is where the contract provides that either party can refer the dispute to adjudication. So there's two rights: a contractual right, where it's stated in the contract to refer the dispute to adjudication, or a statutory right to bring to adjudication, which is pursuant to the Housing Grants Construction and Regeneration Act. And it's all reference to whether or not you've entered into a construction contract and whether or not the exceptions apply. So ultimately, the goal of adjudication is to provide a decision quickly so the project can continue without the dispute causing significant delays or halting work. A decision has to be given in 28 days unless an extension of time has been agreed. The referring party, the party bringing the claim, can agree in its sole discretion to an extension of up to 14 days to the date of the decision. However, any further extension beyond that has to be agreed by both parties. As you can see, it is a very fast process, much faster and quicker than litigation, by way of example, which can take years, unfortunately. So adjudication is crucial because, especially for construction projects, because they rely heavily on cash flow and timelines. When a dispute arises, both parties often want it resolved as quickly as possible so they can keep moving forward. Unlike court proceedings, i.e. litigation, which can take months or years, adjudication offers a fast and cost-effective way to address issues as they arise. This pay now, argue later approach has been transformative for the construction industry, giving both contractors and clients confidence that disputes can be addressed efficiently without holding up the entire project. So, let's now go through the basic steps of the adjudication process. So, the first step of the process is the notice of adjudication. In order to start adjudication, the party raising the dispute, known as the referring party, has to serve what is called a notice of adjudication. This document outlines the issue and the relief that they are seeking. Once this notice has been served on the other party, and importantly it has to be after the notice has been served, you would then issue and get the appointment of an adjudicator. You would need to either look at the contract to see if an adjudicator has been agreed, or apply to an adjudicating body to appoint one, and you would look to see in the contract whether or not a specific adjudicator body, nominating body, has been specified. The adjudicator is ultimately an independent third party, often with expertise in construction law or the construction industry. Once you've then issued your application for the appointment of an adjudicator or approached the adjudicator that's stated in the contract, and before that you've issued your notice of adjudication, the next step is then issuing your referral notice. This is your statement of case, your particulars of claim, and that has to be issued within 7 days of the notice of adjudication. This referral notice, this statement of case, will typically include detailed information, evidence, and legal arguments to support your position. Once you've issued your referral, the adjudicator will then typically issue directions for when the other party's submission in response, has to be issued. And typically the adjudicator normally says that it has to be 7 to 10 days after the issue of the referral. Again, the response would need to include all evidence that they feel is needed to be submitted in time. As you can see though, between 7 and 10 days to issue your response, you don't have a lot of time. And therefore it's really my advice always to keep contemporaneous records and keep it all organised, and be prepared for an adjudication being commenced against you at any time. There would then maybe be further submissions beyond referral and response. You can then have reply, rejoinder, subrejoinder, and the list goes on. But typically there's only normally 2 or 3 rounds of submissions from each party. Once the submissions are then closed, the adjudicator will then reach his decision. As I've mentioned, the adjudicator has 28 days from the date of the referral to make his decision, though as I have just mentioned, this period can be extended by 14 days, which is solely within the gift of the referring party. So the referring party can agree for that date to be extended by 14 days, but should there be any further extension beyond that, then both parties need to agree. The decision, once issued, is binding immediately, meaning that the parties must comply with it right away. If they don't comply with it, then the party that's been successful can commence enforcement proceedings to try and enforce that decision, and that enforcement should be successful unless there's been a material breach of natural justice or the adjudicator lacked jurisdiction. The important point to point out, though, is that an adjudicator's decision is only temporarily binding. Well, what does that mean? It means that either party can later take that dispute to arbitration or litigation if they're unhappy with the decision. It is not appealing it is effectively bringing the claim anew, afresh. You cannot actually appeal an adjudicator's decision. You would need to have to bring litigation and start the matter all over again. So, what are the key benefits to adjudication? Well, the first and most important one I would say is speed. Ultimately, with a 28-day timeline, adjudication is much faster than court proceedings, helping parties maintain cash flow and keeping projects on track. You've also got cost effectiveness. Adjudication is generally cheaper than court litigation, which is beneficial in an industry where time and resources are often stretched. However, having said that, generally speaking, legal costs are irrecoverable, unlike in court proceedings. So if you're instructing me, by way of example, to represent you in the adjudication, whatever legal costs you expend, even if you're successful, you would not unlikely be able to recover that from the other side. In court proceedings, however, it is different. If you're successful in the claim, normally you'd be able to recover 60 to 80% of your legal costs, but equally vice versa, if you're unsuccessful, you'd have to pay 60 to 80% of their costs. In adjudication, if you were unsuccessful, you wouldn't have to pay their legal costs. So there's a benefit as well as a negative in respect of that. Just talking on the issue of whether or not in adjudication you would be whether the other side could be responsible to pay your legal fees, the relevant provision that deals with this in the Construction Act is Section 108A, and this effectively says that provision made between the parties in contracts concerning the allocation as between those parties of legal costs relating to adjudication is ineffective unless it is made in writing, is contained in the construction contract, and confers power on the adjudicator to allocate his fees and expenses as between the parties, or is made in writing after the giving of notice of intention to refer the dispute to adjudication. So it's effectively saying that if you have made an agreement as to the allocation of legal costs, then there needs to be certain requirements that need to be met in order for that to be enforceable. Just looking at adjudicators and who you're looking to appoint, you want to make sure that the adjudicator that's being appointed has the expertise to be able to deal with that dispute. You've got different types of adjudicators, you've got lawyers, you've got quantity surveyors, you've got architects. So depending on the nature of the dispute will determine what kind of expertise you're looking for in an adjudicator. And that's a benefit of adjudications. They will usually be industry experts who understand construction issues. So you should hopefully be confident that you'd get a decision that you're happy with. And then the final positive of adjudication is that they're binding but flexible. While the adjudicator's decision is binding in the short term, parties still have the option to challenge it through arbitration or court proceedings later. So, when should you use adjudication? Well, adjudication is ideal for resolving disputes quickly and avoiding long delays. Common issues that are addressed in adjudication include payment disputes, defective work, delays, issues of extensions of time, liquidated damages. All of that kind of stuff can be referred to adjudication. So what are the challenges and risks of adjudication? Well, first of all, the issue with having a compressed timeline is that Parties need to have evidence ready quickly, which can be challenging if documentation hasn't been well maintained throughout the project. Please see a previous vlog I did which detail what kind of records you should be keeping. The second issue, and I've already alluded to this already, is the issue of rough justice. Because of the speed and the quickness of adjudication, it sometimes leads to what is known as rough justice. The decision may not be as comprehensive or thorough as one that would have been reached in litigation or arbitration. So that's something that you do need to bear in mind. The third thing is that they are only of temporary finality. As I mentioned, adjudicators' decisions are binding immediately, but they are not final. This means that you could face further costs if the dispute goes to arbitration or litigation. So, what are my tips? Well, number one, document everything. This will very much assist if you are bringing or having against you an adjudication. So, keep good records of your project's progress, all communications and financials. Keep all of that information. Adjudicators will rely on written evidence, so the more prepared you are, the stronger that your case will be. The second piece of advice I have is make sure you choose an experienced adjudicator. If you have the choice, sometimes you don't if it specifies who is the adjudicator in the contract, but if you have choice, you want to select an adjudicator with experience in similar disputes. This can be beneficial, reduce the risk of there being rough justice, and they'll make sure that they understand the specific context of your project. So by way of example, if the nominating body is the RICS, in the application form you can specify the type of expertise you're looking for in the adjudicator. The final thing is my advice is to act quickly. Adjudication moves fast, so if you are referring a dispute, make sure you're ready to proceed with your evidence and arguments as soon as the process begins, because it is a very quick process. So that's a quick overview of adjudication in UK construction law. As I've mentioned, it's a powerful tool for managing disputes quickly and effectively, keeping projects on track and maintaining cash flow. I hope you found this helpful. Please like, subscribe and drop any questions in the comments. Thanks again for watching and see you next time.